Welcome all to It's a Wrap, Khaitan & Co competition team's update on the trends from the last year and the outlook for the current year. Uh, Today I am joined by my two partners, Anisha Chand and Pranjal Prateek, two lawyers par excellence. Could we please move to the next slide? Just to cover what all we'd be looking at in the next 1 hour, we'll take a look at the activity heat map, what exactly has happened in the last year in the merger control space. We'll look at some of the key precedents and transactions which were examined by the Commission in the last year. How has the green channel route, which is something unique to India, really worked out? Some trends in imposition of penalty by the CCI, the issue of quorum that we are currently dealing with, the prospective competition amendment bill, which is currently pending with Parliament, and other legislative developments as well. And practically, just to cover up, what do we see happening in this current year and how we see the law shaping in terms of merger control this year. So as I said, I'm joined by two lawyers par excellence, Anisha and Pranjal, both partners in the practice. Moving forward, just looking at the activity heat map from last year, and before I start the presentation itself, one housekeeping rule. There is a chat box on the right or the left of your screen. Please use that to send across questions to us. We'd be happy to answer questions that are sent across, and time permitting, we'd be happy to take them up. So with that housekeeping, I'll just give a quick snapshot of what exactly has happened in the last year. We saw a total of 100 filings in the last year, of which about 54% of all the approved filings by the CCI, and when I say approved filings, I mean Form 1s, Form 2s, and green channels all put together. 54% of them were involving financial sponsors. They were not strategic transactions. When we divide the 100 filings in terms of types of filings made by the parties with the CCI, we saw, again, as is seen every year, majority of them were Form 1, which is a short form filings made with the CCI. About 11 of these are still pending with the Commission, and that maybe to a certain extent has something to do with the quorum issue at the CCI just now, which we'll deliberate upon a little later. Of these 66 filings, 48 were approved without any modifications whatsoever. One was approved with a modification. Similarly, we see numbers on screen vis-a-vis Form 2s and green channels as well. We did see an uptick in the number of Section 43A orders of the Commission. Section 43A primarily deals with gun jumping cases. We saw 11 cases coming up in the last year, 11 orders in which penalties were imposed. We did see a slight uptick in the numbers as well, which we will deliberate upon a little later. This number for the previous year, 2022, was just 2. So there's a significant increase in the number of cases under Section 43A, which were examined by the Commission in the last year. If we can move to the next slide, please. Green channel, again, is something which is unique to India. Just to explain what green channel is, if somebody's not aware, it's a route whereby there is no waiting period for an approval. In this particular situation, if certain conditions are met, such as there being no horizontal or vertical relationships, horizontal overlaps of vertical relationships or complementarity in businesses of the acquirer group and the target, in that situation, a filing could be made through the green channel. As I said, there are no waiting periods, so practically the day when the notice is filed, the approval is deemed to be granted. So this has been a fairly active route to get approvals from. As one can see, of all the approved filings last year, 31% were green channel filings. About 23% of all the filings made by financial sponsors in the last year have been through the green channel route, which gives them substantial and significant relief. It's not considering time is always of the essence in M&A transactions and funding transactions. It's always better if you can have no waiting period, and 23%, which is a significant number of all financial sponsor filings, have been through this route. Intra-group restructuring exercises have not always been eligible for green channels. Perhaps they could be, and that's perhaps something that the Commission can consider in the near future. But a lot of transactions that we have advised on as well, where excuse me, where practically the transaction involves restructuring of family holdings. Those kind of transactions, while they are definitely not causing any appreciable adverse effect on a prima facie basis, they still do require a waiting period and a proper approval mechanism. So that's something which the Commission can consider. In terms of percentages, we saw 25 green channel filings in each of 2021 and 22. We haven't, and practically in terms of percentages as well, it's been pretty much same of 88 and of 94. So maybe there is a possibility for the Commission to consider expanding the green channel a little bit to perhaps provide more leniency and ease of doing business in terms of transactions as well. Green channel transactions are also tied up with the materiality thresholds. We do see certain materiality thresholds in terms of applicability of the green channel, and they are available here as well. In the recent past, and we have seen this, the CCI has attempted to appreciate factual realities and has allowed green channel route to be implemented in cases where there are some issues which perhaps might not qualify our transactions strictly in the green channel route, but they have been considerate and they have understood that really this is not going to be causing a problem. So with that, I'll pass on the baton to Anisha. If Anisha, you could help give our audience a little bit of details of some of the major cases that the Commission examined in the last year, and also if you can help us with some of the trends from gun jumping cases in the last year, that'd be helpful.
Thank you, Anshuman, and thanks to the lovely audience for joining us today. Good afternoon to everyone who's from India, and a good morning to people who are joining from the Europe. So thanks, Anshuman, for those statistics. I think those were very, very helpful, and I think they really set the context for what we are seeing in the world of merger control in India. It is also quite telling of how vibrant the deal activity generally was in India in the last year. And with that, I think it will be only be appropriate for me to look at some of the big ticket transactions not involving green channel routes, which we witnessed last year, starting from the biggest private sector acquisition that we saw, which was essentially Axis Bank's acquisition of Citibank's consumer banking business in India. As you know, all the Indian audience today would know, Axis Bank is third largest private sector bank in India, and post the acquisition, it would have further fortified its position after HDFC and ICICI Bank. From Citibank's perspective, this was a restructuring exercise to really exit from 13 jurisdictions, and India was one of them. The deal size was around 1.6 billion USD, and the deal envisaged an integration of over 3 million customers of Citibank. It was no surprise, given the size of the parties involved, that there were heavy overlaps in more than 30 competing businesses, including loan lending markets, mutual funds, portfolio management services, etc. This was a phase 1 approval, so there were no modifications and there was no phase 2. Which brings me to the second most talked about and one of the most noteworthy cases of last year. This was also, I think this transaction generally had a lot of global interest and was being tracked worldwide. This was nothing other than the PayU's now failed acquisition of BillDesk. Which is as on date the current market leader in India. The combined entity, had the transaction not been aborted, would have had a total of 4 billion transactions annually. And this case is pertinent on many counts. First, it would have created the largest payment aggregator in India by a large difference. And the transaction would have also led to creation of a combined entity that would have featured in the top 10 online payment providers globally. The case was also, I would say, interesting on several counts. First, in a number of markets, more importantly in the payment aggregator space, the market shares would have shot by over 40%, with the second and the third player being a distant second and a third player. There was also a show cause notice that was issued to the parties because the Commission identified certain concerns, competitive concerns that they thought, the combined entity can possibly cause concerns that could possibly arise due to the combination between the parties. But what we did see is that even after issuance of the show cause notice, a lot of arguments, a lot of new data points were presented to the Commission, such as the ability of consumers generally in this market to multi-home, the switching costs being much lower compared to other industries, possibly the banks having and retaining the ability really to impose significant countervailing buying power. So these were all the conditions that were considered by the Commission, and they were okay to not let have the combination have any sort of modifications or commitments, or even go to a phase 2 for a detailed investigation. So I think overall this is quite telling of how this Commission has evolved as an entity who's very business friendly, and who has the ability to sort of deal with these kind of cases without really extracting any remedies, even despite sort of raising preliminary competition concerns. The last decision that I want to mention, and that truly actually deserves mention, is the merger between the two largest Indian broadcasters, which is Sony Pictures and Zee Entertainment. And all of you would agree that these two names are essentially synonymous with general entertainment in every household in India. The transaction will create an entity which would be valued at $10 billion US, and would create the largest broadcaster in India by eliminating a credible competitor in the market. And this would be followed by Disney, Disney Star, and Viacom 18. Obviously, once again, I think it was very apparent that there would be a number of competing business lines and overlaps, some of which related to the operation and wholesale supply of TV channels in India, supply of advertising, airtime, supplying of OTT, AV content, etc. But broadly speaking, I think concerns were raised only in two markets, which was the Hindi language channels pertaining to general entertainment, and Hindi film channels. And in both the markets, what was observed, apart from simply market share, was there could be a number of concerns, which I'll just come to in a minute. But the market share, what it looked like post the transaction, would have been about 35 to 40% for the combined entity, followed by Star. So there was an increment of almost 15 to 20% in all of these markets. So the concerns that the Commission identified was in the market for operation and wholesale supply of TV channels, and the supply of advertising airtime on TV channels. And what were these concerns? Very briefly, the concern was that the combined entity will have huge bargaining power, and it will be able to unfairly self-advantage itself when it's dealing with DPOs, or distribution platform operators, which are essentially sophisticated cable operators and DPOs. And the second concern was in relation to the advertising airtime. So what the Commission observed was this market is already fairly densely concentrated. It is an oligopoly, and with advertising airtime being limited, that could really lead the combined entity to raise the prices for advertisement slots. And that could also lower the quality of the products and services they purchase from the advertisers. And because it's an oligopoly and it has limited number of players, the second and the third largest players would want to follow the price raise that is being raised by the market leader. So these were the concerns, and there were certain behavioral remedies that the parties had proposed to the CCI, which the CCI rejected. But ultimately, the remedies package of divestment of a sale of 3 of Zee's Hindi language channels was finally accepted. That reduced the market shares considerably and assuaged sort of the concerns of the CCI. But I think in gist, I would summarize this slide as under. I would say that overall, all of these decisions evidence the CCI's pro-business approach in general. It signals that the CCI's inclination is to clear matters quickly yet effectively, by attempting to sort of resolve these issues sooner rather than later. And typically, phase 2 processes are onerous and process driven equally for the parties as well as for the authority. And if the party makes a resolution within phase 1, it's really a win-win for both sides. PayU bill desk order is also testimony that the commission is open to having a dialogue. It is willing to listen and change its initial preliminary observations and reverse its initial findings if there are strong documents which can be supported by data and evidence. With that, I'll move on to Anshuman's second question. If you can maybe change the slide, please. So this is certain trends on imposition of penalties in gun jumping, and this is, I'm going to just shift gears to a different topic here, but again, going back to what Anshuman said in the beginning, the statistics reveal that there's been an incline in the number of gun jumping penalties that we saw relative to 2021, where we had a single digit number for gun jumping penalties, which is essentially just 2 gun jumping penalties. In 2022, we saw 11 such cases, and the ticket size of these penalties has also marginally increased. If you see, they have ranged between 5 lakhs to 40 lakhs, which is $6,000 to approximately $49,000. And the average ticket size of the penalty is also near about 20-25 lakhs. The only outlier to this pattern that we are seeing for gun jumping is the penalty that was imposed on Amazon. Why do I say it's an outlier? Because here the penalty was massive. It was 202 crores, which is 2.5 million US dollars. But this was a unique case, and the high penalty was stemming from possible suppression of failure to disclose the strategic intent of Amazon's acquisition in an entity called Future Coupons, who had a direct relationship with Future Retail Limited. But this case is interesting on several counts. But what has recently happened is that the appellate tribunal, which was hearing the appeal from Amazon, has actually confirmed and affirmed the CCI's findings as well as the fine. And it has also affirmed that the CCI's decision to revoke the approval order that was granted to Amazon is legit. It sort of clarified that the right of the CCI to disprove or revoke the transaction is inherent in the right to approve it. But what the NCLAT, or the National Company Law Appellate Tribunal, which is the appellate authority, did was it reduced the penalty marginally by 1 crore. But again, like I said, Amazon decision is extremely critical on various counts. What it has spotlighted is the need to make adequate disclosures in all regulatory filings in a transparent manner, and ensure that there is consistency in representations and submissions across regulators. It has also spotlighted that there is increased scrutiny of internal documents and communications generally. Equally, the presentation of the transaction in the CCI merger filing has to be consistent with your external narrative, and that needs to sort of tally. And what we are also witnessing generally as a trend is that in a lot of cases involving strategic buyouts and investments, we find that the CCI is actively reaching out and seeking internal presentations to really verify the intent and nature of what has been stated in the merger filing notifications, etc., and submissions to the CCI. But if I were to tell you very quickly what these penalties, what were the broad themes involved in these penalty orders, I'd say one is breach of standstill obligations. What do I mean by that? It means that there has been some sort of part consummation or integration between signing and prior to CCI approval, which has happened. So there was one case which involved an acquisition of certain shareholding by virtue of on-market stock purchase on the market. The parties put the shares in an escrow and did not exercise any beneficial rights or legal rights. But the commission said that this is a breach of standstill because you've made the acquisition and you've just imposed self obligation to not exercise the rights. So this was held to be a breach of standstill obligations. We've also seen some interesting cases in the electricity sector where the parties took a stance that even though the thresholds were breached, it did not require prior consent of the CCI, because the Electricity Commission of that particular state in India, which was Orissa in the case that I'm referring to, had exclusive jurisdiction. That was obviously rejected and the parties were penalized. The third common theme that we are seeing across a lot of these penalty orders, at least in the year 2022, is incorrect application of exemptions. And this is important because a number of times when we structure transactions, to be able to take safe harbors or exemptions, there is a mistake, or there is a mistaken self-assessment and in sort of incorrect application of these exemptions. So in some of these cases, what we've seen is that these involved a financial investor who wanted to purchase a minority investment, did not think that CCI approval was necessary, but for a follow-on acquisition, it went to the CCI. CCI discovered that there has been an acquisition in the past, very recent, called the parties, summoned them, and told them that unfortunately you have applied the exemption incorrectly, and therefore I need to penalize you because you've breached the law. So that is really the snapshot, with a key takeaway that you need to consult competition lawyers way in advance. Our laws are very nuanced, they are technical, so we must reach out to the experts in a timely manner to avoid such reputational loss to the companies. Over to you, Anshuman.
Thanks for that, Anisha, and I'll stick on with you here. In terms of quorum, we currently are in a situation where we haven't seen any major orders from the Commission come out since a little while now. Can you give a little more details on what's the latest on that front in the CCI?
Yeah, sure. So if you can just move to the next slide. So we call it, rightly so, the quorum conundrum. It's been causing a stir, and it's a topic that's been grabbing headlines on a daily basis. As some of you would know, our predecessor chairperson, Mr. Ashok Gupta, had superannuated on 25th of October 2022. So it's been 3 months. We don't have a chairperson. Some people like to call it a headless commission. I don't like that expression, but it is true that we don't have a head, except that we have an acting chairperson, as Ms. Sangeeta Verma, who's right now filling in the gap and is the interim ad hoc chairperson until we have a real appointment. And in fact, her tenure as the acting chairperson has just been extended today until we have a chairperson or until she retires. But yeah, the short point is that we are in a deadlock situation. There are no hearings, no adjudicatory functions being performed by the CCI because of the lack of quorum. What is the quorum under competition framework today? Today, the Competition Act in India mandates a minimum quorum of 3 members, and currently we have only 2 members. So consequently, the Commission has not been able to pass any orders for the last 3 months, which is a completely unprecedented situation. I think the only exception is green channel clearances, which is a deemed approval route, which means that you don't need the formal blessings of the Commission. So this is the only merger control clearance which is coming through. Apart from that, we have all the notifications that have been made under a regular approval route are pending approval, and we understand that there are over 16 such cases which are totaling up to a transaction value of over 10,000 crores, approximately $1.2 billion, which are stuck in the process, unfortunately. Obviously, the industry, and I'd say equally the legal fraternity, is not happy with the situation. There are a lot of industry representations that have gone to the government to come up with some stopgap arrangement to remedy this impasse of the situation and come up with some measures to at least there not be any impediment in the deal activity and the deal closing timelines. But as on date, sadly, it appears that this appointment of a chairperson could take more time, and we don't really have visibility, so it could take a few months. Accordingly, what this means is that if your transaction is not eligible for a green channel approval and is notified, say, in the first quarter of this year or the second quarter, it could potentially lead to delays unless the government comes up with some solution. What are the options for the government? Different practitioners have different views, but we think that what is possible and feasible is to temporarily suspend the quorum requirement, at least so far as merger control is concerned, for deal activity to go on smoothly. Second, in case this is easier, is probably appoint a third additional member and not really a chairperson, and continue with Ms. Sangeeta Verma as the acting chairperson. What it will do is meet the quorum requirement, and at least the commission can pass on and conduct its ordinary course activities. The third is the obvious, which is to appoint or expedite the approval of the chairperson, but that's where we are, Anshuman, and over to you with that.
Thanks, Anisha. Pranjal, if I may get you in here, apart from quorum, the other issue which has of course been making a lot of headlines and has been in the news in the recent past has been the Competition Amendment Bill. We did see a draft of that come up in the recent past. Could you take us through some of the major changes vis-a-vis merger control, especially which are proposed in the bill?
Sure, Anshuman, and thank you for everyone joining in. In fact, it's a good day. Coincidentally, just yesterday, it seems that the Union Cabinet has approved the amendment bill in its rigid form after it went through certain changes after the review by the Parliamentary Standing Committee. But just to deconstruct some of the issues from merger control front, we have as you can see on the screen, probably we have some key 7-8 points that we want to discuss here. The first one being on deal value thresholds. I think this has been talked about a lot, and what the amendment bill proposes is that any transaction which has a value of more than INR 2,000 crore, which is approximately around roughly USD $246 million. So any transaction which has deal value of that amount and exceeds that will require approval of the CCI, notwithstanding that such transaction does not meet other jurisdictional thresholds. And that includes the small target exemption. Therefore, even if you don't, even if you are below the small target exemption numbers, but if the deal value itself is higher than 2,000 crore or 246 million USD, the transaction will be notifiable. There is a proviso to this provision, and that states that provided that the party to the transaction meet the significant business operation in India test. And obviously, this is just to establish a local nexus for the deal, and it remains to be seen how that is charted out. At the moment, the bill only says that this has to be decided by regulation. So whenever this is enacted into law, we will see a regulation coming in to help us navigate through what could perhaps amount to significant business operations in India. But it looks like there will be certain additional tests based on either certain presence in India or some monetary threshold based test for presence in India. But obviously that remains to be seen. And then obviously why it was felt that this is important is there are certain transactions, especially on the digital tech side and also service oriented businesses, where we see that perhaps the asset is lesser than what the turnover is, and therefore ultimately the transaction benefits from some of the other of the exemption. And there could be very high value transactions involving smaller entities due to their potential of challenging a large player. So those obviously need to be covered. There has been a lot has been said about those kind of situations, and therefore even the in India the need was felt that the commission should be able to capture and look at those kind of transactions. However, we believe that obviously there could be certain ramifications of this kind of movement. We could probably see that There could be certain transactions where in the infrastructure segment, for example, where the companies have lots of assets, but the turnover could be less, those being captured. And especially on the even on the tech, digital side and startup side, there could be targets which are in constant need of cash, and they can be strapped of that cash because they might come under the scrutiny because of deal value threshold. So obviously there are certain concerns around this area, but we can't just engage in any crystal ball gazing at the moment. We have to see how this all pans out going forward. The second one that you see on the control test, now the amendment bill suggests that the standard to test what amounts to control will be diluted to material influence. And material influence is the lowest threshold of control which is recognized all across the globe, including by the Competition Commission of India. Through various decisions over the years, CCI has clarified that material influence is the lowest standard of threshold. And in fact, while identifying overlaps, horizontal, vertical, or complementary overlaps on deals, on substantive issues, CCI anyway required that the parties, use material influence standard to capture the entities against which these overlaps have to be assessed. However, if it is codified, then that does away with the room that the CCI might have had in the past to do a case-specific assessment. And more importantly, I think from a notification perspective, it will be very clear that when we look at the group definition under the Competition Act and look at the monetary thresholds, relevant to the group, that will also include all the entities that are in the umbrella of being under material influence by the group, and therefore a lot more entities are likely to be captured within the umbrella of the group, and that could lead to higher number of filings. But obviously, again, this is something that needs to be seen how things pan out here, because and we will talk about it a little later, that the Parliamentary Standing Committee had its own views on this issue, and perhaps things might undergo a change there. The third point is regarding reduced timelines. As you might be aware, the outer time limit for CCI to approve a transaction was 210 days, or as on date is 210 days. The amendment bill suggests that it be reduced to 150 days, and the timeline to form prima facie view of whether a transaction causes appreciable adverse effect on competition or not is currently 30 days, which we typically call the phase one period of review. That is also sought to be reduced to 20 days. For these points as well, I think Parliamentary Standing Committee had a different view, and we will take you through that. If the timelines are indeed reduced, then of course that would mean that there will be a lot more burden on both sides. The Commission will be under pressure to issue its decisions very quickly, as well as the parties will be under pressure to sort of collect all the data from different sources and provide it to the CCI in a time-bound manner, and that we believe can lead to a lot more requests for informations probably, or probably even invalidations in such cases. So if this change is indeed carried out, then it looks like the pre-filing consultation before the form, an actual notification form is actually filed with the Commission, will be very important going forward. So the next point that I would like to discuss, one of the key changes is regarding the open offer transactions. So, and CCI has faced this issue previously, where on-market transactions, the stock exchanges or block deals, obviously have to occur right on the market, and therefore there is no time for parties to approach the Commission prior to undertaking such steps, and therefore parties had to bear the brunt of gun jumping proceedings before the Commission. So now the bill very in a welcome manner so has suggested that in open offer kind of situation or block deal kind of situations, the parties can go ahead with such transactions and then come to the commission for approval, provided that in the meantime, until the time that the CCI has approved, standstill obligations will apply, and those standstill obligation will apply in a manner so that although the transactions would have taken place, the parties cannot assume the beneficial interest of such securities which are subject to that transaction. So this is indeed a very welcome move. The next key amendment that we see in the amendment bill with respect to merger control, we'd like to highlight about the modifications, remedies. Previously, when a deal goes to phase 2 investigation stage, it was only upon the commission to offer to suggest certain remedies to the transaction, and only after that a party could have suggested modifications to that proposal, and that would lead to agreement between the party and the commission. That has undergone that is going to undergo a change now. The again, in a welcome manner, the amendment bill suggests that even the parties in the first instance themselves can suggest modifications to the transaction. The next one on the list is codification of various government notifications. So we know that certain informal exemptions have been created under the law, or relaxations. For example, the small target exemption. The small target exemption is now sought to be codified in the law, and therefore it will have a valid legislative basis for exempting certain kind of transaction, and this does away with the need for the government to keep renewing its notification from time to time. Also, in the same vein, Anshuman talked about Green Channel previously. Green Channel right now is under operation through delegated legislation, regulation, the combination regulation. That is also sought to be codified formally into the law itself, which will give it obviously more sanctity. And then lastly, I would like to discuss about certain other delegated legislation. The small target exemption. Many of you are already aware the small target, or the de minimis exemption as we call it, has again been renewed for a period of 5 years until 28th March 2027. Interestingly, this amendment, this was brought in by amending the previous notification rather than issuing a new notification. So the language of the previous notification itself was amended, and the time period was extended to until 2027. Lastly, on the delegated legislation side, we have also seen a movement on Form 2. The Form 2, which is the the long form, which is triggered for filings where the issues are complicated, where the parties exhibit higher horizontal, vertical, or complementary overlaps. In those cases, previously what we saw was that some of the questions were quite burdensome or probably anachronistic. Certain questions were not relevant to perhaps to the assessment that the commission was carrying out. So in line with the Form 1 changes, which were brought a couple of years back, the CCI has now amended the Form 2 also, which is pretty much in line with the concept and the developing on the theories of harm, and looking at the data points that Form 1 looks at. And it has been simplified in some sense, and also in some sense the data burden on the parties has increased, and we see that now the updated Form 2 requires, for example, that the market size or market share of the parties to be mapped for not only 1 year or 2 year, but for 5 years. And therefore it's obviously a very burdensome exercise. For the previous 5 years, now the parties have to give market share data or market size data. Similarly, competitor data, customer and supplier related data has been extended, not only to be limited to the current year or the previous year when the before the transaction took place, but as long back as 5 years from the relevant time period. So this pretty much sums up some of the key issues, some of the key amendments that we're looking at, and also on the delegated legislation front, some of the changes that we saw through the last year. Over to Anshuman.
Thanks, Pranjal. Very insightful indeed. Anisha, coming back to you, in addition to the competition amendment bill, we did see that was referred to the Parliamentary Standing Committee on Finance as well. There was a report on the Parliamentary Standing Committee which came out, and it did suggest some changes towards the draft was proposing. So could you take us through some of the changes and what do we expect the final law to be? As Pranjal mentioned, there is news that this law might be taken up by the Parliament in this budget session itself, and may not go up to the monsoon session as well. So we might have an amended law maybe in the next month or 2 months. But if you could just take us through some of the changes that they suggested to the draft, that would be helpful.
Yeah, thanks, Anshuman. I'll do that. So yes, as Pranjal mentioned, we've just heard today that the competition amendment bill is likely to be tabled during the budget session. So we are hopeful that we'll get all of these good changes in our law, progressive changes in our law very soon. But just to very quickly throw some light upon what the standing committee report was all about. It was essentially a consultation that the Parliamentary Standing Committee did with a lot of stakeholders to understand what the industry concerns are. And has come up with certain, I would say, meaningful recommendations to address those concerns and to identify certain gaps in a more balanced manner. This report came out about a month ago, in mid of December last year. And I would say from a merger control perspective, there are three chief recommendations that they have come out with. First is on the deal value threshold. No prizes for guessing that. There is obviously a concern within the industry, which is that the standard of the threshold or what will constitute the deal value is very unclear and it's fully ambiguous. And this is more so because deal making is increasingly becoming very complex and sophisticated. We don't simply see transactions where there is a monetary consideration and exchange of monetary cash consideration. There is cash, stock, there is deferred indirect consideration, and there are various ways and means in which consideration or value of the transaction can be attributed. So what are those standards going to be is something that all of us and including the industry has been grappling with. To address this, the standing committee report has very helpfully suggested that the commission should be tasked with coming up with regulations which will set out and provide some guidance on how the deal value of any particular transaction is to be computed, what are the components that should be included, and in any case, I'm sure that once and if this law is out and there is a recommendation and the sort of deal value threshold becomes codified in the legislation itself, the commission will also encourage parties to seek pre-filing consultations in case there is any doubt on how the value of that particular deal is to be computed. The second very helpful recommendation on the deal value threshold itself is again stemming from certain industry concerns and investor concerns that the current deal value threshold of 2,000 crores, which is in $250 million US, is probably a little small, and that could attract scrutiny of a number of transactions and could lead to casting the net too wide and catch a lot of unintended sort of deals. So in order to assuage that concern, what the standing committee has recommended is that the central government should be reviewing this threshold on an annual basis, as opposed to what was there in the original bill, which had a recommendation for biannually reviewing threshold. And I think this is relevant because the idea and objective generally is to not have a really, small or tiny threshold such that all sorts of transactions are attracted, but to have a more relevant threshold which is in sync with market realities, so that only the meaty deals or the more relevant deals are caught, as opposed to every single deal that's happening in India. The second one is on approval timelines. As a lot of you attending the session today would know, and as has been mentioned previously, the Commission today has under law a period of 30 working days to approve a transaction, and that's for phase 1 review. So that's the time within which they need to come up with a prima facie view on whether the transaction is kosher, is non-problematic, innocuous, or do I need to look at it in a deeper manner and launch a phase 2 investigation. So that's the initial 30 working day period, which the CCI has, and the outer limit as per current law is 230 days, subject to certain exceptions. This was sought to be reduced and compressed, as Pranjal said, to 20 calendar days and 150 calendar days. What was felt collectively across the board was that the CCI is fairly doing well in terms of timelines. The Commission's track record has been pretty solid, and as per certain publicly stated data, the average timeline for approval of a non-problematic transaction is 17 working days. So collectively, it was felt that the timelines as they are should remain untouched. Status quo should be maintained, and this is gone as a strong recommendation from the standing committee. And this is also sensible because the Commission at present is already understaffed, and this shortening of timeline will only add more burden on the Commission to strive to achieve a timeline which may not really be required. The third important recommendation was in the context of the control test. So as Pranjal has already explained, the bill is looking to define a control to include the standard of material influence, which is the lowest standard of control globally. But what is unclear is, and obviously once you have a different definition of control, it can have severe ramifications and severe implications on the quantum of notifications that become notifiable, or quantum of transactions that become reportable. So it's very important in a suspensory mandatory regime like India, which is self-assessment based, that you have clarity on what constitutes material influence. And to that end, the standing committee has given a clear recommendation that the CCI should come up with, again, guidance and regulations to explain what material influence should be. What we have presently is some fragmented guidance which need to be pieced together, and is based on several distinct factors which could be seen either in isolation or in combination with other factors. But these are related to the extent of shareholding that one entity has over the other, the extent of rights, any board representation rights, what kind of special rights you have in the company, whether there are any structural or financial links, whether there is any special expertise that any particular person has who's shared between the two companies. So these are certain, I would say, very limited number of guidance which is available right now in the CCI's decisional practice, which probably is insufficient. And if you're codifying material influence in the law, the industry as well as the practitioners would need a little more clarity to have that certainty and predictability when they're evaluating whether their transactions are notifiable. So the recommendation is I would say, very opposite, very timely, and it will be helpful to see whether all of these three suggestions finally find their way in the new bill that is going to be tabled before the Parliament this budget session.
Thanks, Anisha. Extremely helpful and insightful again. Coming now, practically, now that we've seen what exactly has happened in the last year, coming to what is in the offing for 2023. Practically, what we see in 2023 at the CCI, at least in the merger control space, is pretty much on the screen right now. And quickly just explaining a few of these points, considering there is a is the quorum conundrum, as Anisha pointed a little while back. We do expect merger case backlog to continue at least in Q1 of this calendar year. We do expect there to be a flurry of approvals whenever either the chairperson is appointed or a third member is appointed, whichever solution the government prefers. But whenever that happens, we do expect a bunch of cases to get approved, but it would take a little bit more time for that eventuality to occur. And once that happens, till that time that happens, this backlog should continue. So hopefully it'll not be too long, and we should have some solution to that. I'm sure the government is working towards it as well. But a certain amount of backlog is expected in the first 3 months of this year. In the event the Competition Amendment Bill, in whichever way and form, is passed in this budget session, or if not in the budget session, in the monsoon session, it is important that the Commission also passes the regulations vis-a-vis a bunch of different concepts which the amendment bill brings up. So one of those topics, of course, on the merger control side is deal value threshold. So we would expect most probably the combination regulations, which are the delegated legislation right now, which looks at the procedural aspects of how filings are made and how the merger process actually is covered at the Commission. We expect those regulations to be amended to bring in deal value threshold, and of course, at the same time, as has been mentioned previously, we expect there to be clarity as to how this deal value threshold would really be applied. In the recent past, we have seen in a number of cases the Commission actually being involving itself in very deep and sophisticated scrutiny of the cases before it, merger cases before it. So we expect that to continue. Over the years, the Commission has increased its capacity in terms of its resources, in terms of the people who are examining these cases. The case teams are extremely smart, extremely sophisticated. They know the variety of businesses in which transactions are happening, and even in the event they are very rarely, as now it happens, if they are faced with a sector that they haven't really examined before, we do see a fair level of engagement to understand what the business really is like. So we expect deeper and more sophisticated scrutiny across sectors to come up as and when cases come up before the merger control wing of the Commission. So that is something which also takes me to the next point, which is of increased interagency cooperation. We do expect excuse me, we do expect heightened cooperation between a variety of other Indian regulators, be it the market regulator or others. And of course, the Commission also has a number of different MOUs which it has signed up with a number of different competition regulators around the world. So we expect interagency cooperation, both domestic and international, to only increase as time goes by, as these different regulators get more comfortable with the CCI as well and its operations. It's going to enhance the cooperation and understanding between them, and that could have an impact on how merger control cases are also examined. Multi-jurisdictional transactions, of course, we have seen the Commission in the past also connect with other sophisticated regulators who are also examining these cases. Therefore, we do expect that interagency cooperation to continue and get even better as time goes by. Coming back to the DVT, which is the deal value threshold, we believe that this is something which would lead to increased filings, which would of course add to the resource crunch of the Commission as well. There would be, once of course we have clarity on what the regulations are and what the exact impact of DVT would be in terms of notifiability of transactions, there is expected to be an increase in the number of filings, which would of course lead to greater stress in the Commission itself. So hopefully we expect the Commission also to enhance its merger control division and add to the quality people it already has. Another portion or change which has already been discussed a fair bit, and that brings me to the last point as well, is that in the event the timelines are reduced, contrary to what the Parliamentary Standing Committee report also has suggested, it perhaps could lead to invalidations and more requests for information as well. The reason we say that is because those timelines are, of course, working days, and they don't account for any clock stops that might happen. In the event the commission does require more time to conduct its assessment, or in the event the parties furnish additional or perhaps more granular data during the assessment period itself, it might lead the commission to either stop the clock or invalidate and restart the clock all over again. So that is a possibility. It adds more stress on the commission itself, as it does on the parties too, and that could have significant downsides as well. So with that, that's a bit of a wrap on what 2022 was and what's in the offing for the current year. We are happy to take questions. Please send those across in the chat box. We already have a couple of them. While it's addressed to me, I'll toss this one to Anisha. Anisha, the first question is: any reasons for such high number of merger approvals without any modifications?
Okay, that's an interesting question. Modifications happen only in cases there is a competitive harm that is expected out of the combination. Indian market, apart from very limited sectors, is largely fragmented. It's unorganized. India is getting to a situation, it's work in progress, where markets are becoming a little more concentrated, sophisticated. You look at any sector and there are many, many players in every such sector. So I'd say telecom, broadcasting, these are probably sectors where all of consolidation has happened and they have matured to a level that there are fewer players. And when transactions happen between a slightly more concentrated markets, the chances of having modifications probably is higher. But in an unorganized market, or where there is excessive fragmentation, there are too many players, a combination of one competitor with another competitor may not necessarily actually lead to any adverse effect on competition. It could in fact be argued that the combined entity may be able to compete better in a more qualitative manner, in a more efficient manner. And therefore the pro-competitive benefits and efficiencies are arising out of competitor acquisition, so to speak, is higher than any sort of adverse effects coming from there. And this I'm going to tie in with the IBC cases that we see, which are already in a lot of financial distress, but all of the bidders are mostly strategic in nature, and it makes sense probably in the overall scheme of the economy to let that buyout happen, even if it's resulting in higher market share in certain times. I'm not saying that this needs to be used as a blanket rule, but it probably makes sense to not let all of those resources go waste, and instead maybe acquire and salvage whatever is left of it to bring it back to and rise it back to a phoenix. So that's probably some of the reasons that I can think of on top of my head to tell you why we don't have cases where there are too many modifications.
If we have a couple of other questions, I think we are towards the end of our time, but let's take a couple of them. If we extend by 5 minutes, I think that should be all right. I'm sorry if I'm eating up into your time. But Pranjal, a simple one here. What is the Green Channel and how does it work? Could you explain in a short time as to how it really works and what the purpose of the Green Channel is?
I think, Anshuman, thanks. I think you spoke a little bit about it. And actually, the term Green Channel has been taken up from, generally the customs that you pass through when you come back to your country or wherever you go, Green Channel and Red Channel. So Green Channel is where you don't have to wait and just go through. And similarly, as the term has been used here by the Commission, it's a sort of their creative improvisation on this, that where transactions do not exhibit any kind of horizontal, vertical, or complementary overlaps, where the parties, the acquirer and the target are completely unrelated in terms of the sectors that they operate in, and there cannot be any, sort of in very colloquial terms, if we could say that there couldn't be any sort of collaboration between them after the deal to the advantage of either party in terms of the products and services that they offer, then the CCI just doesn't look at those cases. All you have to do is file the form in a simple manner, and as soon as you get the acknowledgement, that is the end of the story as far as CCI is concerned, and you are free to complete your transaction. Therefore, there is no waiting period. So that's how I can very simply explain it, and probably it also takes care of the fact why is it important.
Perfect. Anisha, I know this is something that you are fairly passionate about, so I'll address this one to you. Please share your opinion on the possibility of a digital company and the ex-ante regulation of digital markets as recommended by the Standing Committee of Finance. Do you think that Indian markets are as mature as the EU and the US that call for ex-ante regulation? So, any thoughts on that?
Too many thoughts on that to communicate over a short webinar, but
This is a webinar
there
in
is
itself,
no
actually, this
right.
question.
Yeah, so but no, it's a very relevant question, so I'm going to try and answer this in the shortest manner possible. There are proponents on both sides. India is seeing a digital revolution in every way possible. We have produced the highest number of unicorns, I think, after the United States of America. We have seen a flux of investments during COVID period. We are also seeing a downfall in the technology companies which receive that funding, but that's a discussion for another time. But the short point that I'm trying to make here is India is a haven for digital innovation today. The government is mindful that investments are key. Foreign investors have to find India as an appealing destination. At the same time, it wants to safeguard, protect, and encourage innovation, unicorns, and keep that incentive to innovate alive. Right? How do you balance these two things? Because what has happened in the West and what is also happening in India, and I think Pranjal in his presentation had alluded to it, is that there is there are a lot of what we call killer acquisitions, where a bigger company which is established, probably one of the big tech companies, decides to acquire another small company. And I wouldn't say that it's not that when startups come about, they don't aspire to be actually getting acquired by these. So their probably aspiration is to come up with something, catch the attention of the big guys in the tech space and get acquired. That could be their aspiration too. But the point is that everybody should have the ability to make their own choices. And what's been seen in the past is that there have been a series of acquisitions where a big tech company has acquired a smaller company which had a novel technology, which could have probably been able to challenge those big tech companies, but they have been acquired at a nascent stage, and nobody else apart from the big tech had the know-how or wherewithal to be able to identify such a company and what it could be, whether it could be a threat in the future to them. So to be able to, and a lot of these merger regulations don't have the ability to review these transactions because they are small in size or the target is inconsequential. So what has happened over a period of time is that a lot of novelty or small such companies have been acquired without being notified, and those are the deals that people want to notify. So all the countries across the world are actually taking measures, either through taking policy measures or through legislative measures, to be able to remedy that gap. And India thinks that because it is in the center of innovation and technology revolution, it probably needs to act now. What is the best way? I'm not sure whether the best way is to legislate a new law or to wait and watch how developments in the West go. But I'm equally cautious that we should not be in a position where we have missed the bus and then trying to play catch up. So I don't really have the right answer, but we really need to, we're walking on thin ice here, and we need to carefully consider both the proponents and see what is the best way forward for India. And I'm sure the overlords up there sitting in the parliament will apply their minds in the right manner.
Thank you so much for that. With this interesting response and question as well, I think that gives us enough fodder for our next webinar as well. There are a couple of questions. I'm mindful that there are a couple of other questions which have come into the chat box, but unfortunately, with the time that we have, we're not able to answer them right now. But we will definitely get back to you over email and connect with you separately. But thank you so much, Anisha, Pranjal, for taking our time and explaining what 2022 was like and what 2023 is going to be like. Thanks for the audience. Thanks for the audience as well for taking our time to hear us. If you have any questions, please feel free to reach out, and hopefully we'll have an interesting 2023. Thank you so much.